Good morning. Today is Thursday, May 27, 2021. I have two calendars this morning. Let me take care of the shorter matter first. Is there a Felicia Washington here for a name change?
Yes, ma'am, I'm here.
Okay, let me see your face. Okay, ma'am, go ahead and raise your right hand, please. You solemnly swear or affirm the testimony that you're going to give should be the truth, the whole truth, under penalty of perjury. You're muted.
Sorry.
Okay, did you hear my question?
Can you repeat it? I'm sorry.
Sure. Do you solemnly swear or affirm the testimony that you're going to give should be the whole truth under penalty of perjury?
I do.
Okay, go ahead and lower your hand. At the time that you filed your petition for a name change, did you live in Clayton County for at least 6 months?
Yes.
And you filed it and was published in the Clayton News Daily, is that correct?
Yes.
Tell me what name you're requesting to be changed to.
Yokana Leora Israel.
Tell me why you want to change your name.
Due to religious purposes.
You're not asking to have your name changed for any fraudulent or illegal purposes, is that correct?
Correct.
And the court will grant your request to change your name to Yukana Leora Israel.
Yes.
Okay, I will sign an order today and we will process it through the clerk's office and you'll get it within the week, okay?
Thank you.
Welcome, good luck, be safe. Calendar 2 is my criminal calendar. Let me go ahead and call the calendar. Position 1 is Zariah Muhammad.
Good morning, Your Honor. Attorney Leah Madden here on behalf of Ms. Muhammad. She should be on the call.
Good morning.
And Your Honor, the state would just ask for a brief breakout room with Attorney Madden and probation if they're on.
Okay, can you guys hear me?
Yes, Your Honor.
Okay, it looks like my Zoom is about to go out. I don't know what this is. I'm gonna proceed until it does. Technical issues here. Position 2, Chris Little.
The state's ready.
Good morning, Your Honor. Mr. Little's present.
Okay, there we are. Chris Little. Motion to dismiss indictment with prejudice.
Yes, ma'am.
Are you
Good morning.
represented by counsel?
No, Your Honor, I'm pro se.
State ready.
Yes, Judge.
Position 3, Dominic Hodge.
Good morning, Your Honor. Attorney Coleman Watkins. I'm standing in for Attorney Foster. I think she just logged in for Dominic Hodge.
Okay, this case hasn't been indicted.
Yes, Your Honor, it has not. We're on for a motion to modify the bond conditions.
Okay, all right, let's go into a breakout room, position 1. Is the probation officer on? Is there a probation officer?
Your Honor, I'm on, but I tell you, please. You
No.
want me to see if I can reach out?
No, ma'am. Are you waiting for probation officer, Attorney Miller?
Your Honor, I may be able to resolve it if I can just speak with Ms. Madden briefly. Otherwise, we would ask that probation be here.
Are you asking for a breakout room with Attorney Madden, or are you asking to approach the bench?
Just with Attorney Madden at this time.
Okay. Okay, I've sent you guys the link. Go ahead and accept it.
Thank you, Judge.
And everybody else, just be patient.
And Your Honor, if myself and Attorney Madden can just approach the bench briefly.
Sure. Attorney Madden, do you see your new link?
No. Judge, I'm sorry, you said what now?
A new link to go into the breakout room.
Oh. No, I don't see it. We just came out of the breakout room.
Right, I'm putting you back in one so I can talk to you guys privately.
No, I understand, Judge. I just didn't, I don't see
Okay,
it.
give me one moment. Let me move you to 1. Don't accept this one so that I can move you back to 2. Do you see that? Room 2.
Yes, I see it now. Okay.
Okay. Okay, there, as to position 1, Zariah Muhammad will be taken off the calendar. Attorney Madden will have an opportunity to speak to her client. I don't see her on the screen as of yet. And then make an announcement to my office, and Ms. Miller will follow up with probation, okay? So 1 is off. Position 2, Chris Little. The state of Georgia versus Chris Little, case number 2015 CR 02520. Motion for dismissal of indictment with prejudice. Mr. Little, this is your motion.
Good morning, Your Honor. This is Mr. Chris Little here, pro se defendant for the defense. I would like to initiate and reserve all my pretrial rights. I filed a motion here for motion for dismissal of indictment with prejudice based upon the Interstate Agreement on Detainers Act, which can be found under Georgia Code OCGA 42-6-20, Article 3D. Okay, subsection Article 3D of Georgia Code under the Interstate Agreement on Detainers Act is essentially what they call an anti-shuttling provision, which says that once a jurisdiction files a detainer on a prisoner that's being held in another jurisdiction while he is serving a sentence, that prisoner has the right to request a final disposition of his case. And once that prisoner requests a final disposition of his case and forwards the associated documents, the receiving state has 180 days to bring the prisoner to the requested jurisdiction and have him ready for trial. There's also another provision which can be found in specifically 3D that says that prisoner, once he is in the receiving state, shall not be returned to the sending state unless that case that he was brought to the receiving state, which is Georgia, Clayton County, for, is disposed of. Okay, so allow me to actually go through this motion for a second and specify what took place. The alleged incident on which this indictment is based took place on April the 28th, 2011. The initial arrest warrant and detainer was served upon the defendant on September the 20th, 2011, while the defendant was in Fulton County Jail on unrelated charges. The defendant was initially taken into custody of Clayton County Sheriff's Office for the indictment on May 31st, 2015. And a true bill of indictment was returned in December 2016. December 16th of 2015. The defendant posted bond on their said indictment on December the 23rd, but remained in custody until January the 5th of 2016, based on outstanding warrants in Broward County, Florida. A succeeding arrest warrant and detainer for the instant Clayton County indictment was issued for failure to appear, while the defendant remained in Broward County Jail on those offenses unrelated to Clayton County. The defendant was subsequently sentenced in Florida and transported to the Florida Department of Corrections, and was again notified of the outstanding detainer in Clayton County, Georgia. Okay. At that point, the defendant made numerous unsuccessful attempts with prison authorities to initiate the Interstate Agreement on Detainers Act provisions. Okay. Essentially, the defendant was successful and filed those documents in compliance with the Interstate Agreement on Detainers Act. And you can see them inside, contained within the motion exhibits C, D, and F, requesting final disposition of the indictment, of said indictment that we're here for today. Okay, Clayton County Senior District Chief District Attorney Cheryl Friedman and this honorable judge here, Shana Rooks Malone, accepted and acknowledged receiving the defendant's request for final disposition and associated documents on October the 1st, and that'll be Exhibit G. Said documents were signed and dated by both parties. The defendant was transferred from the sending state, which is Florida, Holmes Correctional Institution, where he was actively serving the sentence, to the receiving state, Georgia, Clayton County, on February the 18th. You can see Exhibit H, and I think that's a transportation order, and remained there until December the 4th, at which time he was returned to the original place of imprisonment before trial, thereby violating the IADA, Interstate Agreement on Detainers Act, Article 3D. Okay, and to give you a little breakdown, I'm not sure if you know exactly the provisions of the IADA and what it contains, but the IADA is active in 48 states in the federal government and the District of Columbia, and entered into as the in the United States Code on the 18 Section 2. And it's also codified in Georgia Code, annotated OCGA 46620, and creates a uniform procedure for lodging and executing detainers, a legal order that requires a state in which an individual is currently in prison to hold that individual when he is finished serving his sentence, so that he may be tried by a different state for a different crime. The IADA provides expeditious delivery of the prisoner to the receiving state for trial prior to the termination of the sentence in the sentence state, and seeks to minimize the consequent interruption of the prisoner's ongoing prison term and rehabilitation. Okay, I have a United States Supreme Court case here, Alabama versus Bozeman, that states that if those provisions are violated, that the court shall enter an order dismissing the same with prejudice. Okay, on the most recent detainer that was lodged against the defendant by the receiving state, Clayton County, the provisions of the agreement were triggered, and the receiving state are bound by such. And you could find that statement right there in United States versus Morrow, 98 Supreme Court, 1834. Okay, which states under the Interstate Agreement on Detainers Act, which prescribes procedures by which a member jurisdiction, by filing a detainer, the member state is bound by the agreement when it activates its provisions by filing a detainer against a prisoner. Okay. Essentially, Clayton County violated the Interstate Agreement on Detainers Act by bringing the defendant from the jurisdiction in which he was serving the sentence to Clayton County and returning him to that jurisdiction again without disposing of the case. And that can be found in Article 3, subsection D of the Interstate Agreement on Detainers Act. And the Interstate Agreement on Detainers Act clearly identifies the required relief if its provisions are violated. It says specifically, such indictment or information or complaint shall not be of any further force or effect, and the court shall enter an order dismissing the same with prejudice. That could be found on the Article 3D. In the United States Supreme Court case, Alabama versus Bozeman, the defendant showed diligence and full compliance in satisfying the requirements of the IADA, the state being bounded to the provisions of the agreement, accepted and acknowledged, and was fully aware of its terms, still returned the defendant before trial to the original place of incarceration. The shuttling of the defendant back to the original place of imprisonment with the same detainer intact ensured that he would have to be returned again to the receiving state, thus preventing him from qualifying for work release program to reduce his sentence and effectively hampering his rehabilitation. Wherefore, the defendant requested this honorable court to adhere to the provisions of the Interstate Agreement of the Detainers Act, and this motion be granted, and this indictment be of no further effect and be dismissed with prejudice, Your Honor.
Mr. Hawkins,
Thank you, Judge.
you disappear there for a moment. You may respond.
Your Honor, the state is asking that this court deny the defendant's motion. I believe the defense and I agree on just about all the facts of this case. As far as the timelines, Mr. Little was indicted in 2015. Mr. Little, or on October 1st, 2019, my office acknowledged receipt of Mr. Little's request for final disposition. The Honorable Court also acknowledged receipt of that. Mr. Little was brought from Florida to Clayton County, Georgia. However, before the 180 days expired in which the state had to try Mr. Little, the COVID-19 pandemic occurred. And on March 14th, 2020, as this court is well aware, the statewide judicial emergency commenced, suspending all jury trials. So Mr. Little was not able to be tried within that 180 days because of the COVID-19 pandemic and the statewide judicial emergency order suspending jury trials, which are still suspended within Clayton County on this date. Your Honor, on prior Mr. Little returning to Florida, on October 29th, 2020, Mr. Little filed a motion to reinstate and reduce his bond. That motion came before this court, and on November 18th, 2020, this court issued an order setting aside Mr. Little's bench warrant and reinstating his bond. That was done in light of the fact that when the bench warrant was issued for Mr. Little's arrest for failure to appear, he was in custody in Florida. After this court set aside Mr. Little's bench warrant and reinstated his bond at his request, at Mr. Little's request, Mr. Little was then transported back to Florida, where he was still serving his prison sentence out of Florida. And that is very key here, Judge, because Mr. Little's conduct, his actions actually were contrary to the interstate agreement on detainer. And because of that, he has waived his right to that for that anti-shuttling provision. Your Honor, I want to cite to State versus Johnson. It's a Court of Appeals case out of Ohio. It is an Ohio case, but I'd like to remind the court that the interstate agreement on detainers is uniform. It is in 48 states, and the language of the law within those 48 states is substantively the same. So Ohio's interpretation of the law, they're dealing with essentially the same statute that Georgia courts would be dealing with here. In this Ohio case, and the site is 2016-Ohio-7036. There's also a Lexis site that I'll refer to, 2016 Ohio app Lexis 3896. It's a 2016 case. And in this case, the defendant argued that his indictment should be dismissed because due to the anti-shuttling provision, and that he was brought from Pennsylvania to Ohio. But when he was in Ohio, he posted bond and then went back to Pennsylvania to finish out his sentence. And he argued that under the anti-shuttling provision, his indictment should be dismissed with prejudice. However, the Ohio appellate court rejected that argument. Notably, the Ohio court cited the Ninth Circuit, United States v. Black, 609 Federal 2, 1330. It's a 1979 Ninth Circuit Court of Appeals that states the rights and protections created by the IAD are statutory rights, not fundamental or constitutional in nature. As such, a defendant may waive his protections under the IAD. The Ohio case, jumping back to the Ohio case, it states, it does not matter that a defendant does not knowingly or intelligently waive his IAD protections. Under the IAD, waiver is shown by proof that the prisoner has affirmatively requested to be treated in a manner contrary to IAD indicating waiver. In the Black decision, again, that's that Ninth Circuit Court of Appeals from 1979 states, or the Ohio court quoting Black states, the court held that a defendant may waive his or her protections under the IAD's anti-shuttling provision, even where they do not do so knowingly or intelligently. So what we have here is even if Mr. Little did not knowingly and intentionally waive his rights under the anti-shuttling provision, his movement to reinstate bond, to set aside that bench warrant, that was contrary to his rights under IAD, and thus the courts in Ohio, and I'll cite to a Missouri case, have ruled that that is a waiver of his rights under the anti-shuttling provision. Specifically, I want to also cite to State versus Vinson, the Missouri case. The site is 182 Southwest 3rd, 709. It's from 2006. And in that case dealt with a very similar facts that we have here. In the Missouri case, the defendant arrived into Missouri from the sending state. And when the defendant arrived into Missouri, he posted a $10,000 bond. Thereafter, he was returned to the sending state, which was Illinois, by members of the local police department. And this was done without knowledge of the state attorney's office. The Missouri Court of Appeals ruled that the defendant's return back to Illinois was the result of his voluntary affirmative actions. The court stated the defendant's voluntary affirmative act of posting bond resulted in his being transported back to federal custody, which was in Illinois. Although the defendant did not specifically request to be returned to federal custody, his act of posting bond resulted in his return to the federal penitentiary. We find this act constituted an affirmative request for treatment in a manner contrary to the IAD. Pursuant to the IAD agreement, defendant agreed that the agreement shall constitute a consent by me to the production of my body in any court where my presence may be required in order to effectuate the purposes of the Interstate Agreement on Detainers Act, and a further consent voluntarily to be returned to the institution in which I am now confined. Once again, Judge, this is two different states, and again, they're interpreting the law that is substantively similar from those states as the law is here in Georgia. Two different states, Missouri and Ohio, that have interpreted this anti-shuttling provision that it can be waived by the defendant, that it does not need to be waived knowingly and intentionally, but that a defendant's act of posting bond, of seeking to be released from the receiving state, acts as a waiver of the anti-shuttling provisions. That's exactly what we have here, Judge. It's without dispute that Mr. Little filed his motion to reinstate and reduce bond on October 29th, 2020. That's his motion that came before this court. The state prepared an order that this court signed on November 18th, 2020, setting aside that bench warrant and reinstating Mr. Little's bond. After doing that, at Mr. Little's motion on his request, Mr. Little was transported back to Florida. The only reason he was transported back to Florida is because Mr. Little initiated this process to reinstate his bond in the Clayton County matter. That's the only reason he left the state of Georgia after being brought here. So, Your Honor, because of that, because the case law is clear, again, it's not Georgia law, but they're interpreting the similar statutes from in two different states, two different jurisdictions. This court should deny Mr. Little's motion. Notably, Mr. Little did cite the Bozeman decision. However, both the Vinson case, and it's Vinson, and the Johnson case distinguish the Bozeman case because, in Vinson and Johnson, the defendant took affirmative steps to post bond and act in a manner contrary to the IAD. So, Your Honor, for those reasons, the state is asking that this motion be denied. I also want to point out that even though the 180 days was suspended by the judicial emergency order, the provisions of the IAD are only in effect while the defendant remains under sentence or incarcerated from another jurisdiction. Mr. Little, as you can see, is no longer in custody. He has paroled out on his Florida case, so therefore the 180-day requirements no longer apply. So when we do resume jury trials, this is not a case that needs to be heard within that 180 days because Mr. Little is no longer in custody. But for those reasons, Judge, the state asks that this court deny Mr. Little's motion.
Mr. Little, you have closing on your motion.
Okay, the defense will agree with the state on a number of issues, namely that the defense did actually file that motion for the bond to be reinstated and reduced. But if you notice, the title of that bond, the title of that motion is for that bond to be reinstated and reduced. Okay. The defendant wasn't requesting for immediate bond. The defendant wasn't requesting to be immediate released. The defendant was requesting to have the right to post a bond given back. Okay, hence, that's why he asked for it to be reduced. If the defendant had any knowledge that the bond would be given back without having to be posted, without having to provide funds again, there would be no reason to have argued for the reduction in that amount, which the defendant did do and was denied. That portion of the motion was denied, the reduction part, and was told that I would have to pay the $60,000 again that I initially paid to be released. There was no knowingly or voluntarily waiver. The state made notation, made mention in his argument, in his rebuttal, that the defendant specifically requested after that motion was granted to be returned or transported back to the facility that he came from. I would like for the state to provide that actual request, because that request was not made by the defense at all, was not made by the defendant. The defendant made no written request to be returned back to the original place of imprisonment or verbal request.
Mr. Little, if you posted your bond, where did you think you were going?
Your Honor, I didn't post the bond.
Okay.
I was under the
Your bond
impression
was reinstated. How did you leave Clayton County Jail?
I was transported back to
Why?
the original place
Because you had bond posted?
because the bond was posted.
Okay, go ahead.
But I didn't post the bond. The bond was reinstated.
Reinstated at your request.
Yes, ma'am.
Okay, go ahead.
Okay. The 180 day is not the issue here. Okay, the issue is the anti-shuttling provision and the defendant being brought back to the original place of jurisdiction. The cases that the defendant cited in here, which is Alabama versus Bozeman and Alabama versus Bozeman are United States Supreme Court cases from 2001, which supersedes the case that the state mentioned. The state mentioned the case from 1979. The Alabama versus Bozeman case is in 2001, and it's from the Supreme Court, the highest case in the land. All right. The defendant did not request to be sent back to the original place of jurisdiction. All right. The relevant portion of the statute clearly mandates for dismissal with prejudice if the anti-shuttling provision is violated. All right. There was no request for the bond to be actually reissued, like I said originally. At the beginning of the hearing, in which the defendant asked for the bond to be reinstated, the defendant requested to have his all procedural protections and rights reserved, just like every hearing that he has defended himself in. And according to the court, that bond was originally forfeited. So in order for that defendant to actually be released back on that bond, the funds would have to been provided again. There was no funds provided. The defendant, after contacting the Clayton County Jail, was told that he was released administratively and not by a posted bond. So therefore, Your Honor, the defendant's requesting that this indictment be dismissed with prejudice based upon violation of the Interstate Agreement on Detainers Act in Georgia Code and the United States Code. The defendant was negatively impacted his rehabilitation because of being shuttled back and forth. And even one day of shuttling back and forth will cause this negative impact. Therefore, the defendant's asking for the motion to be dismissed.
Court's going to take it under advisement. I was looking for my prior order. I don't see it in the file to give a verbal order from the bench, but I will take it under advisement and issue an order within 7 days. Anything further from either one of you?
No, Judge.
Okay, Mr. Little, you're free to leave.
Thank you, Your Honor.
You're welcome. Position 3, Dominic Hodge. State of Georgia versus Dominic Hodge. Case number is a TS number 2019 TS 10217. This case is not indicted as of yet. This is defendant's motion to modify conditions of bond. Ms. Foster, you may present your motion.
Your Honor. Your Honor, before this court, my client was arrested in November of 2019.
Wait a minute, Ms. Foster. Who is Mr. Holly?
I'm sorry, he is Mr. Hodge's father, and I believe his mother.
Okay.
Oh, she's there as well. I'm sorry.
Is he testifying?
Yes, Your Honor, he is.
Call him as a witness. Mr. Holly, mute your camera. Let me reposition this. 406, what deputy is in 406? Everybody's here on Zoom. You guys are free to close for my division for today. This is my last calendar.
Okay, thank you.
Thank you. Have a good week.
Sure.
Okay, go ahead, Ms. Foster.
Yes, Your Honor. My client received bond in November of 2019. This case is, he was charged as an armed robbery. He was 16 years old at the time that the case occurred. He was accused of basically being present when the armed robbery occurred. He was granted a bond. Part of that bond was that he be on ankle monitor. He has been on ankle monitor since then. His parents are paying, or he and his parents are paying $290 a month for Mr. I'm sorry, Your Honor, let me just pull it up. For Mr. Hodge to be modified.
Your motion says 560. That's not right.
We included, and that was my error. They had to take out a loan to bond him out. So I made the mistake. We included the total amount they were paying a month for this case. It's $290 for the GPS monitoring device, and then the remaining amount is the loan amount, Your Honor. I apologize. That was an error that we made, but it's $290 for the GPS monitoring. And I do have Mr. Holly here. Before I kind of go into everything else, Your Honor, I would like to call him just to kind of go over the financial aspect of what they're having to pay while Mr. Hodge is on bond.
Ms. Pitts, you have an opening, or do you want to just go to testimony?
No, I'm fine with going straight to testimony.
Okay, Ms. Foster. Mr. Holly, go ahead and share your screen or come back on screen. Ms. Foster is going to call you as our first witness.
Yes. Mr. Holly, if you raise your right hand. Do you swear to tell the truth and do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, Mr. Holly, please tell the court how you are related to Mr. Hodge.
I'm his stepfather.
Okay. And Mr. Holly, when your stepson was arrested, did you and your wife have to bond him out?
Yes, we did.
And did you have the funds to bond him out?
No, we didn't.
What did you have to do in order to be able to bond him out?
We took out a $9,200 loan to pay the percentage to get him out.
Okay. And did you have to pay for, in addition to that loan, did you have to pay for anything else?
The ankle monitor fees,
Okay. And how much are you paying in the fees?
$290 for the last 17 months.
Okay. And are you paying back the loan at the same time that you're paying the $290?
Yes, we are. It is a high interest loan. It's about almost 36%.
Okay.
So
About how much a month are you paying when you combine the GPS and the loan?
well, after we did the math, it's over. I say about 630 after we actually did the math. It's equaling it's 290 for the ankle monitor, and it's 343 a month. And when we actually did the math, it came out to about 633 a month that we're paying.
Okay. This amount that you're having to pay, has that caused a financial strain for you and your wife?
Yes, it has, especially with the pandemic. I was hurt on my job, and I went out on workers' comp. I was eventually separated, and she had like over a 20% pay cut when the pandemic hit. So Dominic actually started working to kind of help us make sure that we could pay the loan and the ankle monitor fees.
Okay. And since your son has been home, how has he been doing in school?
He's been doing good. The grades that we get through the parent portal, he's making A's and B's. He's almost caught up. He's gonna try to take a couple of classes this summer so he can try to graduate on time.
And the paperwork that we submitted, Exhibit A, that was attached to the motion. Your Honor, do you have the motion, or would you like me to share my screen?
For evidentiary purposes, you'll have to share your screen.
Okay. I'm going to show you, Mr. Hodge, what we have marked as Exhibit A. Let me know if you can see my screen. Oh, can you see the screen?
Yes, I can.
Okay. What do you recognize the screen to be?
Look like it's classes and completion percentage.
Okay. So when you're saying that, and did you submit this information to me?
Yes.
Okay. And when you're telling the court that he's doing better, you submitted this information as Exhibit A, correct?
Yes.
For the court. Okay. Your Honor, I move to admit Exhibit A into evidence.
Any objection? Ms. Pitts?
No, Your Honor, no objection.
So admitted.
Okay. And Mr. Holly, so your son is doing better in school, and you mentioned that he has also been working, correct?
Yes, that's correct.
And where does he work?
He works at the Holiday Inn in Peachtree City.
Okay. And how long has he been working there?
I'm not sure. I want to say at least about a year off and on.
Okay. And did you?
I'm sorry.
Go ahead.
I was gonna say he was working there, and then with the pandemic, he stopped, and then they asked him to come back.
Okay. And did you submit a character reference letter to me from Linda Garcia?
Yes,
Is that the general manager of the place where he works?
yes, it is.
Okay, I'm gonna share my screen again. What has previously been marked as Exhibit B. Now, you don't have to tell the court what the letter says, but do you recognize that letter? This letter?
Yes, I do.
Okay, what do you recognize it to be?
It's a letter from his general manager.
At the job that he works at?
Yes, ma'am.
Okay, Your Honor, I move to admit Exhibit B into evidence.
Any objection, Ms. Pitts?
No objection, Your Honor.
So let's do this. There are a number of letters attached to the motion. They're not affidavits. Have you seen the motion, Ms. Pitts?
Yes, Your Honor.
Do you have any objection to their character statements?
No, Your Honor.
Okay, Ms. Foster, just admit them all together.
Okay.
And also, I didn't receive any of the exhibits, just when you all get a chance. I'll need to receive those.
Okay.
Thank you.
Let me continue sharing my screen. Okay. Mr. Holly, this is Exhibit C, which is a letter from Eric Willis and Terrence Dunstan. Did you submit those letters to me? Can you hear me? Okay.
Yes.
And Your Honor, I move to admit all the letters. I'm sorry, in addition to Ms. Bailey Jones. I move to admit all the letters, Your Honor.
Are you doing those under separate exhibit C, or are you tying them back to exhibit B?
They were actually all under Exhibit B, Your Honor.
Okay. And Ms. Pitts, for the record, there is no objection to them being omitted.
Correct, Your Honor.
Okay, so omitted.
Thank you, Your Honor. So, Mr. Holly, in addition to the fact that your son is, since this incident, he's doing better in school, he's working to help you guys out, and you guys are basically under a financial strain since this case has been pending since 2019. You are asking this court to allow your son to be removed, the ankle monitor to be removed, correct?
Yes.
Okay, Your Honor, I have no further questions for Mr. Holly.
Ms. Pitts, do you have any questions for Mr. Holly?
Yes, Your Honor. Good morning, Mr. Holly. My name is Zena Pitts. I am the Assistant District Attorney for the state involving your stepson's case. At the time of bonding Mr. Hodge out of custody, you were aware that the ankle monitor was part of the terms of that bond. Is that correct?
Yes.
Okay. And you received a bond amount and conditions predicated on him having that ankle monitor. Is that correct?
Yes, that's correct.
And you understood at the time of this that that ankle monitor was part of the reason that he was granted bond. Is that correct?
Yes.
Okay. And he is in fact still on bond, correct?
Yes, it is.
Okay. And that condition was part and parcel of why the court granted that bond. Is that correct?
Your Honor, I would object. The cause for speculation.
Your Honor, I would say he can answer if he knows, and if he doesn't, that's fine.
Your Honor, he's not the judge. He doesn't know why the judge
I'm
granted
going
the
to
bond.
sustain the objection.
Okay. Mr. Holly, you submitted documentation that counsel has introduced in reference to Mr. Hodge's student progress, correct?
I'm sorry, I didn't hear you.
Did you provided documentation that that Attorney Foster has introduced for Mr. Hodge's student progress? Is that correct?
Yes.
Okay. And does Mr. Hodge go to in-person school, or is this progress report based on virtual school?
It's virtual because of the pandemic.
Okay.
So it's taking virtual.
Okay. And based on your testimony, are you at the house currently, and would you have been during the period of this progress report?
Yes, I'm out of work, so I'm home all the time.
Okay. And looking at that progress report, Exhibit A, when you submit it, you would agree that the progress report indicates that in American literature that there were 5 tests given, and Mr. Hodge did 3 of those 5.
I don't have the paperwork with me, but if that's what it says, then yes.
Okay. And if we look at what you submitted as a progress report for Mr. Hodge, that in algebra, there were a total of 5 tests given and Mr. Hodge completed 2.
Okay.
Okay. And so when you say he's doing better, are you saying he's doing better than when this armed robbery was committed or something different?
When I say he's doing better, I say he's doing better overall. I mean, when we sent you that, I don't have an updated one. I do know that he has completed a high percentage of his classes. So by the time that paperwork was submitted, so we can go ahead and file this motion, he probably did only complete 2 of them. But I know we've been working with his teachers to try to get him caught up so that he can take these summer classes and so he can graduate on time. So at the time of the submission of the paperwork, that may be where he was. That doesn't necessarily say that that's where he's at right now. We would have to look at, I guess, get some updated ones to kind of show his full progress, but he's still on pace for graduating on time.
Okay. So to be certain, the exhibits that were entered do not reflect the do better that you were testifying to.
That's correct.
Okay. All right. I have no further questions, Judge.
Just want to,
Any redirect, Ms. Foster?
yes, just brief clarification. Mr. Holly, your son, you mentioned that he is done with his classes and he's on par to graduate, correct?
Yes.
Okay, and I'm going to share my screen really quickly with you again, because I know that you couldn't see it when you were speaking with Ms. Pitts. Can you see my Exhibit A?
It says 71.4 completion.
No, I mean, can you see the Exhibit A?
Yes, I see it.
Okay, so where it says overall grade for American literature, your son had an 87%, correct?
Yes.
And his overall grade, again, for another American literature is 88%, correct?
Yes.
And for algebra, it's 90%, correct?
Yes.
And I don't know if they have this listed twice, but then there's another one that's 85%, correct?
Yes.
Okay, and for human anatomy, it's 92%.
Yes.
Okay, so maybe they're listing this twice. So it's 92% and it's 88. But in addition to what you submitted at the time that we filed this bond, your son has finished school on time and he's on par to graduate, correct?
Yes, that's correct.
Okay. Your Honor, I have no further questions.
Anything further, Ms. Pitts? For Mr. Holly? Okay, any other witnesses, Ms. Foster?
No, Your Honor.
Okay, all right, you guys have argument?
Yes, Your Honor. At the time that my client received bond, of course, his parents didn't expect this case to drag on as long as it can. And without kind of going into the facts, there had been discussions with the state about, even prior to today, about trying to resolve this case. So in addition to the pandemic, in addition to Mr. Holly losing his job, they had no intention to pay a never-ending GPS monitoring fee. This fee has caused a financial strain on them, even with Mr. Hodge getting a job while he's in school to help his parents out. This is a case that I hope that we can resolve, Your Honor, but we don't know when this case could end. And bond is not, should be reasonable, Your Honor. Mr. Hodge has shown since he's been out since 2019, there's been no violations of bond. He's done everything the court has expected of him. He's doing well in school. He has gotten a job. He's helping his parents out, and he's not been in any trouble. We would argue that to have him continue to be on ankle monitor and continue to place a financial strain on his parents and him is unreasonable, and goes against the statute, which says that bond, that everyone is entitled to a reasonable bond. Because of the evidence that we've presented, we would ask the court to grant our motion to modify bond to allow Mr. Hodge to no longer be on GPS monitoring, so that it could be a relief to him and his parents financially.
Okay, Attorney Pitts.
Your Honor, the state would object to the removal of the ankle monitoring. I believe that it's clear that the ankle monitoring was part and parcel of the rationale for the bond that counsel would have agreed to at the time of making of the bond, and that the longevity of it does not make it now unreasonable. Your Honor, the defendant received a $50,000 bond on an armed robbery of a 15-year-old and a 17-year-old. I do not believe I do not believe that counsel's statement that the defendant was merely present is consistent with the evidence that was presented during the bond hearing, and that both the victims in this case testified that this was a joint operation between the defendant and an unknown assailant, and that there was a firearm present. And very shortly thereafter, Mr. Hodge was in fact found in possession of the juvenile's phone and items. This happened, Your Honor, as these juveniles were walking home from school, which I think leads itself to why the defendant's whereabouts and are a need to know in response to the crime that he committed. I do not believe that an ankle monitoring is an unreasonable circumstance based on the facts and the circumstances of this case. And for those reasons, Your Honor, the state would ask that you would not modify this bond. I do agree with counsel that we do expect that we will have some movement on this case very shortly, hopefully, and we would be moving towards resolution.
Anything further from you, Ms. Foster?
No, Your Honor.
The court will grant the motion to modify. However, I'm going to remove the GPS ankle monitor, but I'm going to impose a curfew. Your curfew will be 7 p.m. to 7 a.m., which means between the hours of 7 p.m. and 7 a.m., you must be at home. I don't have the prior file, so to the extent there was no mention of staying away from the alleged victims, that will be added to the bond conditions. Any questions?
No, Your Honor.
All right. Good luck to you, sir.
Yeah, would you want me to submit the proposed order?
No, I'll have it.
Okay. Thank you, Your Honor. May we be excused?
You may be. That concludes court for today. Everybody is excused. You all have a good weekend.
Thank you, Judge.
Bye-bye.